but you guys are going to unite together as representatives of our community of Harris County, Texas, and you're going to speak on behalf of our community on this case. When you go back and start deliberating, one of the first things you may say is, why did this case go to trial? They had a video, they had DNA, they had eyewitnesses. And while you may wonder that, there are three things that every defendant has the right to that none of us can impact. The first one is the lawyer that he chooses to hire. You get to hire whoever you want to hire. The second thing is whether or not you want to testify. That decision gets to be made solely by the defendant himself. You may disagree with it. You might think it was a bad idea, but he gets to make that decision. And the third thing is every defendant gets to make the decision of whether or not they go to trial. Doesn't matter if we have a really difficult circumstantial case that the state's proving, or we have a case like this where the evidence seems to be overwhelming. Every defendant gets to make that choice and that right. And so as you begin your deliberations, don't let those things get in the way or the thought process that you're talking about. Those are rights that he gets to choose. In voir dire, we talked about, in jury selection, we talked about self-defense. And I told you that at the time I had no idea what the defense would be, and I didn't even know if this would come up. But if you'll remember when we talked about it, I told you that if self-defense was in the charge, it doesn't mean that the judge is telling you that self-defense is appropriate. It doesn't mean that you have to find self-defense. The judge is required to put it into the charge if there is what we call a scintilla. That's any little bitty bit of evidence. That evidence doesn't even have to be credible. And on the evidence that you have before you, there is not a scintilla of evidence that he was entitled to self-defense. But he chose to get on the stand and make these claims that are not supported by the evidence, but make claims that required the judge to put it in the charge. When you look at that, you view his testimony with the same eye that you view all the other evidence. You line up his testimony with the evidence that you have before you, with the evidence of Hortensia Poa, with her testimony and what she said happened. You line it up with the testimony of Yami Romero and what she said happened. You line it up with the video that you can see with your own two eyes. And the law is not, does he think he was reasonable? Oh no. The law is, would a reasonable person have responded in that way? And I gave you three important things that in order for deadly force to apply, three things must exist. Number one, it had to be immediately necessary. The answer to that is a big fat no. He had every opportunity to get in his truck and drive away and go home. Jeffrey Limmer was inside McDonald's picking up his to-go order. So he loses on that right there. Is it reasonable? Would other ordinary folks like ourselves have responded in this way? No. And Lord help us all if that's the society that we want to live in. That we can be gunned down and ambushed over a fish fillet sandwich. And finally, was Jeffrey Limmer using deadly force? No. He loses on, he's strike three, you're out. And so as Mr. Cager is up here talking to you, I want you to remember those three things. Was it immediately necessary? No. Was it reasonable? No. And was Jeffrey Limmer using unlawful, deadly force? No.
Thank you. Mr. Cager, whenever you're ready.
Good evening, and gentlemen of the jury. On May 4th, a tragic event happened. Mr. Limmer lost his life. But before that day, my client and Mr. Limmer never knew each other, never crossed paths, nothing happened. But on that day, my client got there at 4 o'clock, as you all know. He ordered a fillet of fish, and it wasn't up to his liking. It was missing a patty. So he ate it, took pictures of it, and came back. He didn't know Mr. Limmer was in there for anybody else in there. So he's talking to the staff, asking them, can he get a refund? He's talking to them, asking them, well, I don't want a total refund. I just want for my patty. And we can't. People are particular about their food. I'm not, but he's had the right to be there. And we saw the discrepancy in sizes between my client and Mr. Limmer. Mr. Limmer, very big guy. My client, a small guy, disabled but a hip. So automatically, it's definitely a difference in size. My client never said one word to Mr. Limmer. You can look at the video. When he got there, he never said anything. Mr. Limmer looked at my client, arguing with people he allegedly thought, but it was a language barrier. He was asking him, tell him I just want my money back. It's not the order I have. And Mr. Limmer, out of the blue, started cursing at my client. An argument ensued. They cursed each other out, and then my client got his money. And you saw on the video itself that Miss Hortensia wasn't even there when he was arguing with the first lady that helped him. I believe her name is Romero. Ms. Romero said I couldn't, she couldn't help him. She talked to him about 2 or 3 minutes, and then somebody else came to help him. Miss Hortensia didn't come in until after the whole issue was over. Well, he was getting a receipt. She came in and saw the last argument. The last argument when Mr. Limmer was telling him, get the fuck out of here, or else. Well, Mr. Limmer, my client, once he got a receipt, turned around and said, F you, I got my money back. I got my refund. So at that point, 3 seconds passed. Mr. Limmer's in the store, my client walking to his car. But for Mr. Limmer's action of attacking my client outside, we wouldn't be here today. Mr. Limmer is also a lawyer. He knows better than to assault somebody at a McDonald's over their own money. He should be held to a higher burden. I know better than that. So once he attacked my client, you saw the video, with one hand, he pushed them over 3 feet. Over 10 feet, one hand. Just imagine if he'd have punched them. Just imagine if he'd hit my client with a head, broke his hip even further. Just imagine if he did hit his face on us. Just imagine his face. It wasn't no bruises from a fight. It's a bruises from the semen on the scratch, like a brush burn playing football. That's what happened to my client. And he had elbow injuries from getting slammed on the ground. Now, you can see in the video, before that happened, you can see my client walking out with his wallet at the top of his left pocket. You see this, it's in the color video. That wallet between him getting attacked and him getting slammed was missing. He told you already that he had the gun on his hip in the first place. If he wanted to shoot Mr. Limmer, he could have shot him when he pushed him down. He wasn't coming in there to shoot nobody for his own protection. So he don't have a right to go back into McDonald's and look for his wallet? I think he does, Your Honor. I think he does. So as he going back in there, he said, well, I'm gonna pull my gun, and just in case he try to attack me again. And you can see in the video, my client stepped 1 foot inside the door, not even inside the door, and Mr. Limmer is coming at him. And then at the same time, if you go back a few seconds more, you can see where he's on the opposite side of the McDonald's. And Miss Hortensia is saying, well, I think he might have a gun. You need to stay with it. He didn't, you heard us say that. He didn't do what he did. He walked hurriedly with that bag in his hand like that and pushed my client out, and that's when the firing began. What my client supposed to do? Let him attack him again? What my client was supposed to do? Let him do whatever he had in the bag? You heard the testimony of the first officer. She said she had a call that there was a weapon involved at the scene. And then she said that they had a shell inside his bag. That shell didn't match none of the shells that were fired. I'm not saying he had a gun.
There's no evidence of that.
Yeah.
There's no evidence they matched, there's no evidence they dealt, there's no ballistics evidence testing, was there? Just where did that come from?
Yeah.
Limit yourself to the evidence that was shown.
Yeah, she didn't even object. I mean, what's going on? I'm going against this judge in the prosecutor?
Objection to sidebar at this point.
Objection to sidebar, please limit your questions and your remarks to the evidence in this case.
So what are you supposed to do? Wait till you attack him again? Wait till you get him better this time when he's facing him? And back to that, how would he invite somebody out to fight him? Man, literally about the size, but why would you turn your back if you invite somebody out there to fight you? He'd be outside waiting to fight. That didn't happen. That was made up. And I don't even think it was made up by Miss Hortensia. I think the lead detective to your detective in homicide told him to say stuff like that. The reason why I say that because in all his office report, he never said anything about interviewing him or have any interviews available.
Objection, Your Honor. Facts, not evidence. Also misstates testimony.
Well, if his initial report on forward, you say he's collecting. You heard him say that. He said, I just collect evidence and then I make my reports. I add them to the report later. He added to the report 2 months later. Once he already knew my client's name, once he already had his theory on what happened with the case, he didn't try to find no evidence. He didn't try to look and see if Mr. Lambert's car was there. He never went to his apartment. He didn't even know where he lived at. And he came to trial, supposed to be the lead detective with that much evidence. And the state tried to bring in race, a racial slur. My client worked with 2 Hispanic guys for over 7 years. Race wasn't the issue. He didn't make a racial slur. But they're trying to inflame the jury panel. They try to inflame the trial effect. You see, it's a racial issue. But it's no racial issue. The only person that said something racial was Mr. Limmer. Called my client a boy and get the fuck out of here. I want you to look at all the 3 angles on the camera. They say that Mr. Limmer got his food and was just walking out. You can see him walking from the left side of the McDonald's. And Miss Hortensia telling him, no, stay back. We're just marching there anyway. And she said, she must have thought, you heard her say, that he must have thought they just want to fight again. So he pushed my client before he comes through the door. What is my client supposed to do? What is a reasonable person to do? Let him slam you again or attack you, let him hurt you worse? That's reasonable action. He fired him back. Well, he fired at him, preventing him from assaulting him again. Now, there's no limit on how many shots you could fire. I mean, he shot as long as he thought to keep him from coming after him. As long as he thought it would take for him not to hit him from the back again. The question is, what would you do? Let's say you was in Mr. Landry's shoes. Let's say if I came behind you and pushed you down, and then you came back and I rushed at you, what would you do? You would fire. You would fire. And you would be reasonable in fire. You don't know me. You don't know what I have in that bag. You don't know anything about me. So you're supposed to take a chance that he's gonna kill you, I'm gonna kill you. That's reasonable. And Ms. Hortensia testified that she was there when he was arguing with the first, she wasn't even in the video. Look at the video. Let's go to credibility. Now, like I said, I don't think she made it up, but she's trying to help them make the case. And you heard Officer Martinez on the stand. Every time I asked him of something I believe should be important, whether or not he had that, he said, well, no, I don't have it right now. I didn't put it in my report. So what do you come to trial for? Why was he here? I don't have it here? I mean, that's not proof beyond a reasonable doubt. That's a reasonable doubt. Why you don't have the statements from the day of? Why you don't have the statements when you go search his locker room? Why you don't have the video for that?
Objection. This states the evidence and the testimony.
Same drill was made for the evidence
Y'all have the right to get the transcripts, and if I'm lying, you can determine that. But he said everything he didn't have a video saying that he went to the video when he went to the apartment. He didn't even know what the apartment was till the state told him, and he's the lead detective. I mean, I want you to look at the entire video. They got all three angles where you can see, not just a little montage they made, because they didn't want you to see him walking towards the door before he got shot. They left it out. I provided that for you. They left it out because they knew he was going to fight him again. And that's what my client believed. And you can see in the long event, Tiska tell him, go back. I think he got a gun on him. Go back. He still came anyway. I don't know if he had a gun, but he still came anyway. She warned him, and he still went for it. So what is my client to do? What is a reasonable person to do? Let him attack you again, possibly hurt you even worse, or defend yourself. And also, it's not stated in the charge, a person convicted of a felony does have the right to defend himself. If you were already attacked by somebody much bigger than you, slammed to the ground, just because you cursed them out, what would you think would happen if you go back inside the McDonald's looking for your wallet? Isn't it reasonable to be thinking you are feared to be under attack again? I'll submit to you that is reasonable. And like I said, you can see on the video that he put his wallet in his front left pocket and it's sticking out. So it's almost positively came out when he got slammed to the ground. You saw how far he pushed him. You saw how high in the air he was when he got pushed. And the state talked about how my client could have left the scene. My client could have just left and went home and left his wallet. But if you look back at the time frame, 3 seconds passed when my client took his receipt and was gone home. 3 seconds, everything would have been over. We would not even be here. Mr. Limmer would be alive, my client wouldn't be charged with this crime at all. But Mr. Limmer, for whatever reason, wanted to attack somebody much smaller than him. He talked about it in the case in chief about bullying. Who was the bully in that? Who was the bully of you were almost 6 foot tall, 6'4", 240 pounds, pushing a man who's crippled at 5'8", 58 years old at the time. He's 12 years younger than my client, and he was a healthy man. Now, the state said I told you y'all not supposed to. I say you come to the individual verdict. What I said was correct. I'm not saying y'all can't agree, but you gotta come to your own individual verdict based on the facts and the evidence presented. And then y'all come to whether or not, if y'all do come to an agreement, so be it. But no one can berate you or believe you for your verdict. It's your own verdict based on the evidence and the facts. I want you to look at the full video in all angles to get the whole concept of what actually happened. Not just a 2 second, 3 second montage that they gave you. They show you what they wanted to see. They didn't show you how he got to the door. They didn't show you the video of him getting attacked. I'll show you that. They never showed that. Why? Because they know Mr. Limmer was the aggressor. And also, he came to the store in the 5 in the evening with a 6-pack of 16-ounce Coors Light, with all kinds of stuff in the bag, a gun shell in the bag. Man, my client is reasonable to believe that he had something in that bag. but for Mr. Limmer pushing my client down and my client losing his wallet, we wouldn't be here today. Mr. Limmer could have stayed in the store, stayed in the store after my client left, and wait for his order like he was supposed to do. Now, like I said, it's sad that Mr. Limmer is no longer here. But at the same time, people have the right to protect themselves. At the same time, everybody's mom tell you keep your hands to yourself. Big as I am, I know better than that. I don't go around pushing people in the street for somebody else's business. The same thing could happen to me. Same thing could happen to you all if you did that. Now, the burden is whether or not my client acts as a reasonable and prudent person in using self-defense. Would you think it's reasonable for you, for a female to be, a small female to use that force based on the same facts? I think that's reasonable. If somebody big like that pushed a female, knocked her to the ground, and she had to go back in there, she needs to be armed. That's reasonable. Put yourself in those shoes. Not that he's a man, just put yourself in the shoes and what would you actually do? Close your eyes and what would you actually do if all that stuff happened? What would you do to make it home? And he said call the police. It's on video. He wanted to get his wallet, so he had to leave his wallet there before confronting the man. So he brought his gun for protection. And you can see the gun is not pointing like that. It's like here. And he come at it, then he pointed. He has the gun in his right hand. He's left-handed. So he didn't come in to shoot him. He's left-handed, the gun was in the right hand. So that wasn't his intention. But at the same time, if it's somebody running at you who actually attacked you forcefully like that he did, and he had a bag in his hand, do you take chances of whether or not he don't have anything in it? I think not. It's reasonable. And self-defense is not just for the affluent or lawyers, it's for everybody. If the shoe was on the other foot and my client was a victim in this case would never go to trial.
Objection, Your Honor, that's completely improper.
Sustained your disregard that.
So, as the charging instrument says, you have to put yourself in his situation, whether or not you believe a reasonably prudent person would act the same way after being attacked once and possibly being attacked second time. I ask you all and Wardell for y'all for y'all to hold the state to the burden of proof of proving each and every element beyond any reasonable doubt, each and one of them. And also to put yourself in my client's shoes if you were attacked by this person you don't know or possibly being attacked twice. I ask you to make this jury process one that you would want for yourself and your loved one if you were charged. Do you think it's reasonable for your daughter to react that way or your son to react that way if a man trying to attack them twice, big as he is? I think that's reasonable. I ask y'all to hold the state to their burden of proof. I ask y'all to come to a verdict of my client being not guilty of murder due to self-defense. Thank you.
Judge Landry, sir.
Okay. So, I want to talk to you all about the actual evidence in this case. All of the exhibits that we admitted, including both copies of the video, the original and the compilation of the cuts, that was us that admitted them. We're not trying to hide any portion of the video for you. We were the ones that admitted that evidence, so you can have that if you want it. But I'm going to be honest. You've watched this video enough times. You have watched Jeff Limmer die enough times. You have sat there with him enough times and watched him die on the ground take his last breaths, try to tell someone, help me. You can forgive yourselves and take pride in your verdict in finding him guilty. You don't need to watch it again. But if you want to, the option is there. Feel free to take it. Now, what Mr. Cager told you is not evidence. The 0 exhibits he admitted are not evidence. What is evidence is what you saw that we presented and what all of the witnesses testified to, including Mr. Landry. So I want to go piece by piece, starting at the beginning of this case, and walk through to the end. This case actually doesn't start on May 4th of 2024. This starts 20 years ago when Mr. Landry is a convicted felon and is sent to prison, because he then loses his right to possess a firearm outside of his home. He cannot carry one on him. And then it continues into February of 2024. And in February of 2024, when he decides to beat his daughter with a cane so bad he sends her to the hospital and loses that same cane, he's also assigned bond conditions where he's not allowed to have a firearm once again. He has 2 separate things that have notified him. You do not get to carry a gun. That's the person we have to judge whether his actions are reasonable or not. And so we walk into May 4th of 2024, where he has decided to bring a gun with him in his work truck to McDonald's. Now, on its face, you have a guy who got a curbside order at 4:30 for a fillet of fish. And his order was only missing 1 patty on a 2-patty fillet of fish. Now, I don't assume to know every one of you and your internal thoughts, but I don't think it would be a giant leap for me to say none of the 13 of you would probably even bother going back an hour and a half later to even go get the refund. It's $1.41. I mean, come on. And you certainly, if you're going back for that refund, are not going back in there heated and yelling at the staff over 1 patty being missing on a 2-patty fillet of fish sandwich. That's ridiculous. It's completely unreasonable to start with. It shows someone who has a horrible temper, who will be set off at the most.
People evidence not in the evidence.
It's argument.
It shows someone who will get angry at the smallest little thing.
Objection, Your Honor, it's not into evidence, Your Honor.
It's a counsel's argument is what the evidence has shown.
And he walks in heated. You can tell, even though there's no volume on that video, you can tell he's heated from the beginning because you can watch all of his hand gestures. You can watch how loud he's being, how he's directly pointing at people, how he's just pacing around really uncomfortably, just standing there, roaming around basically all over the McDonald's. How he's, basically puts the bag on the counter there. You can tell he's heated. And you can also tell from the other people that are in the restaurant, from the waitstaff to Jeff, that Mr. Landry is clearly heated already because you just see Jeff keep looking to the left, just keep glancing. Something's going on. And so that's the person we're dealing with here. Then, he's not content, like I told you earlier in this trial, he's not content with yelling at the waitstaff. When Jeff says something to him, tells him to calm down, to be quiet, to leave, he then gets pissed at Jeff. That's who he is. He's already so heated and in the moment that he then directs his ire to Jeff. And, reasonable minds might differ on what someone would do in that situation, right? There are people like Jeff out there who will say something. There are people like Jeff who will stand up for people. And there are people that would hope someone would stand up for them if they were in that situation, but may not do something. And there are people that may just sit back and say, I'm not going to deal with that. It's not my problem. But honestly, it really doesn't matter. It doesn't matter which one of you, or which one of those that you are, because at the end of the day, Jeff is doing nothing wrong. We can all agree on that. He's in there, in a McDonald's, ordering food. He just wants his dinner. And he's trying to do something that he thinks is right in that situation. And does he ever use deadly force? No. He uses his words to tell the man that we've had enough of you. And then, after all of that happens, what does the defendant do? The defendant is still so angry, he challenges him to a fight. And we heard multiple witnesses say that. We've heard one witness say that he challenged him to a fight that was there that day. We've also heard another witness say that the defendant was cussing her out and said things like, well, you don't speak English very good. We've heard that. It's consistent. Everybody there seems uncomfortable by what this man was doing. So why then would we believe all of them are liars because he says so after we've seen what he's done on that video? But take it a step further. He's not content with just yelling at everybody. He clearly, as he's walking out after that refund receipt that he gets, he turns around and he looks at Jeff. And why else is he turning around unless what the witnesses say are true? Unless what they're saying is true, that he is turning around to challenge him for a fight, it makes no sense. Because he goes to that door and he stands at that door and holds it for a few seconds. He waits for Jeff to come. That's what the video shows. He's waiting for Jeff because he challenged him to a fight. He told him, let's take it outside. It's what the witness said. It's the truth. It's what the video shows. Even if he says contrary, the evidence is what it is. And after challenging Jeff to a fight, Jeff doesn't even fight it. He pushes him once because this man has taken enough space up in his life that he shoves him down onto the ground and he walks back into the McDonald's. The amount of bruising to this man's ego is the real problem. It's not the bruising on his face or his arms that we can't see in that booking photo. It's the bruise to his ego that really hurts. Because to him, he can stand up and argue and get his way and cuss out wait staff, and after being the bad guy, he challenges a guy to a fight, and the guy won't even fight him. He just won't even fight him. So that's why he went to his car and he got a gun. Because he's not done with the situation. His ego's bruised. He's really angry. He is ready to take a life at this point. And he walks back into McDonald's. Now, he will tell you that he walked back into the McDonald's to get his wallet. There are many reasons why that's not true. The first reason is because we can see on the video him grab his wallet and start to put it in his pocket as he walks out. But the second, which is just very logical and obvious, is that the shove that happens where he says he lost his wallet is outside the McDonald's. Why, if he's shoved outside the McDonald's, does he need to go back inside for his wallet? We all know why he went back inside the McDonald's. He's digging in the car for all of about 2 seconds before he emerges. He knows what he's looking for in that car. It's the gun. He doesn't have it on him when he's shoved. He gets that gun, he goes back into the McDonald's, and as he told you, Jeff charged him. Jeff did not charge him. You can see that video, the angle that Jeff is standing when the defendant is coming in and starting the shooting. he is standing not straight forward towards the door, but at a side angle. And the defendant comes in and shoots him, not once, not twice, 10 times. He shoots him 10 total times. And we talked to you with the medical examiner about those injuries. This is the other reason we know Jeff doesn't charge him. And the reason I can tell you that is because look at how many are on his front and on his back. There's 1, 2, 3 on his front. Sorry, 4 on his front. And the reason there's really only 3 is because we talked about how A and B are just one bullet. And that's going at a side trajectory. And then we have the one in his pelvis and the one in his hand. Then we have a ton in the back and 2 on the side. Question for you. How do I know this? Well, if you go back and watch the video, you will see where the defendant stands over Jeff as he is laying on the ground dying and shoots him multiple more times. When he shoots him again on the ground, Jeff is laying on his back and a little bit to his side. When he shoots him when he's on the ground, those are the bullets we're getting in the front and on the side. The bullets that Jeff is getting shot with that are at the door, those are the ones in his back. Because he's not getting the ones in his back while he's laying down. He's getting the ones in his back while he's running away from him. As we can see on the video when he slides backwards away from the door. This man was never charged at. So we lied about that again. Then what does the defendant do? The defendant then decides to leave the McDonald's, get in his car, doesn't do his daily routine for the next 6 days, doesn't go back to work, doesn't do anything but hide out. At some point, he talks to his sister, we learned today, and tells her that he shot someone, and then eventually 6 days later, after this finally hits the media and becomes circulation for all of us to see, he finally turns himself in, doesn't bring the gun with him. But it actually doesn't even end there. It ends here today. Because that not being enough for Anthony Landry, shooting someone 10 times, including 5 times in the back, wasn't enough for him. It wasn't enough to be done with his anger at Jeff in that moment. He got the choice to testify. And he took that ability to testify where everybody swears under oath to tell the truth. And he decided to disrespect that by lying to all of your faces. He decided to disrespect that by lying about a man who can no longer defend himself. He decided to disrespect this man by telling lies about him. A man he killed by shooting in the back. A man that you watched die on video multiple times. A man that you watched die at his hands while he stands over his body bleeding out and keeps shooting him. So here's the real question. If this is self-defense, was the first shot self-defense? No, because there's no deadly force and there's nothing imminent about any of the altercation at that point because he's already left and gotten the gun. And there's no deadly force because there's no deadly weapon. And it's not reasonable because the entire situation is unreasonable and Mr. Landry shouldn't have put himself there. You know, we've heard a lot of, well, but if Jeff did this or if Jeff didn't do that, then we wouldn't be here. If he didn't shoot him 10 times, we wouldn't be here. That's the real but if. We are here today, make no mistake, because he is a murderer. He has killed Jeff Limmer and taken his presence from us on this earth. He has left a family without their son, without their brother. He has taken away someone from our community that clearly people cared about and that clearly he did not, over something as senseless as $1.41. He is willing to start an altercation and take a life over $1.41. Does that sound reasonable to anyone here? Hope not. But even if you take what Anthony Landry says is true, which you shouldn't, it's not honest, but let's just say you do for a second, he's still guilty of murder. And why do I say that? Because there's no deadly force. There is nothing he testified to in all of his testimony to you that amounted to deadly force. Period. The end.
The proper closing, he's not gonna prior effect, jury prior effect.
It's in the proper objection to make.
There is nothing he testified to that is deadly force. Not a single thing. So that actually takes a lot of the weight off of you for this portion of the trial. But I don't think this portion of the trial is really what matters. Find him guilty, because he's guilty under the law, and let's get on to the punishment phase, where things really matter.
Thank you. Ladies and gentlemen, now retired from jury room.
All right, period.
Thank you. Y'all can be seated. Jury's verdict. Mr. Taser, you've made certain comments regarding my family and their connections to this case. I would like to examine all evidence you have about that. So how long will it take to get you to connect to your evidence? You believe my family and my wife was connected to this case, specifically my wife and my children. How long will it have for you to get that evidence here that will back up those claims?
And I want your evidence to correspond between the state and
Stop
the
it.
states.
This is not, no. I asked you a direct question. How long will it take you to get that evidence?
There's the one thing I look on the internet. That's what, that's the evidence came from.
You've get everything you have that purports to be what you said is true, because you are being held to account on that.
Okay.
You understand?
Yes.
And if you cannot be held to account, there will be a show cause of it. You insulted my family, you insulted my honor, and you've disparaged them, knowing darn well they have nothing to do with these cases. Anyone in this room.
Did your wife go to law school in South Texas?
You bring your proof as to how my wife and my children have been over at their house, anybody's house,
I've never said
have been
that.
part in
I've
their,
never said
in their
that.
neighborhood. You did too, sir.
No,
Bring your proof. I will check on the record. You will be held to account.
I know what
Every one of those statements, sir.
Okay.
We're at recess for right now.
Yeah. See ya.
So were they, so whatever, was it for both? Or was it just for the Oh, the mayor. I've never seen that before.
Lindsay, you ready to go? Yep, let's bring him in. No, we'll send it back out and figure out life.
All rise for the jury.
All right, thank you. Please be seated. Ladies and gentlemen, has the jury reached a verdict? All right. Mr. Landry, will you please stand? In cause number 1867402, the state of Texas versus Anthony Landry, we the jury found defendant Anthony Martin Landry guilty of murder as charged in the indictment. You decide which to have the jury polled?
State does not.
Yes, I do, Your Honor.
All right. We all poll the jury. All right. I'll go one by one, ladies and gentlemen. When I ask you, is who's my alternate first of all? Yes. Make sure we're not asking you. Ma'am, is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
This your verdict in the front row? This your verdict?
Yes.
Back row, sir. Is this your verdict?
Yes. Yes. Yes.
And finally, thank you. Ladies and gentlemen, we'll be with you momentarily. All right?
All rise for the jury.
That's fine. I put you guys in. Thank you. You can be seated. Mr. Gray or Mr. Childers, how many witnesses y'all gonna have in punishment? 9. 9? All right. When will your first witness be here?
We need to do the fingerprints very briefly. She's already rolled them. We just need to talk to her really quickly.
Okay.
And then we have one on the way from the Children's Assessment Center. He was on patrol at the time. He just got moved to the Children's Assessment Center, so he's on his way. And then we have other witnesses here, and then we have one witness coming from court. She'll be here shortly.
All right, we'll be in break for about 15 minutes then.
Okay.
So Landry, man of the custody sheriff.